Great. Good afternoon, everyone. My name is Charla Rios. I have she, her pronouns, and I'm a researcher at the Center for Responsible Lending. I'm excited to be a moderator today for our webinar focused on a report entitled Debt Under Duress, the Economic Impacts of Bail Bonds on San Francisco Bay Area Residents. And I'll be introducing our speakers. Next slide. So in addition to myself, we have a great panel for you all today, and they'll also be introducing themselves as they go through some of the themes. But we have Rio Scharf with the Lawyers Committee on Civil and Rights, San Francisco Equal Justice Works Fellow. We also have Lucia Maddox, who is our CRL Director of Western States Outreach and Senior Policy Associate, and as well as Pete Smith, who's a senior researcher here at the Center for Responsible Lending. Next slide. So for our agenda today, there's a few different things that we will make sure to cover. First is our purpose, which is our project partnership with LCCRSF. The purpose of our research, as well as our research questions, how bail bonds work, thematic findings, as well as recommendations. At the end, we'll have a question and answer period, so you all are welcome to put your questions in the Q&A box that should be listed on your webinar panel. Next slide. So our purpose for this webinar is to provide an overview of the Debt Under Duress report. And you all, if you haven't been able to review that report, this webinar will provide you a high-level overview of that report specifically, as well as we would like to share context of the bail bond or cash bail system, specifically in California, and have some of that information for stakeholders both in California and beyond. We are inviting an interviewee to share some of their experiences while dealing with bail bond debt, and also exploring opportunities to work towards ending cash bail and harmful pretrial detention. Next slide. So with that, I'll turn it over to our first speaker, Rio Scharf, to share a little bit of remarks from his perspective. Rio.
Hi, everybody. My name's Rio Scharf. Good to see those of you here who I've already met, and nice to meet those participants who I haven't had the chance to meet. I am an Equal Justice Works Fellow with the Lawyers Committee for Civil Rights of the San Francisco Bay Area. In that capacity, among other things, I run the Bail Clinic, which is a legal services organization that assists people who have bail bonds debt. And you can go to the next slide, please. The Bail Clinic was created out of the notion that bail bonds consumers, people who sign bail bonds contracts, they're consumers just like anybody else, and they are entitled to all of the consumer protection rights that so many other consumers in California have access to. Unfortunately, for decades, bail bonds consumers were overlooked. They weren't given the legal assistance they deserved as consumers. The bail bonds industry was seen as falling at sort of a weird niche between the criminal legal system, insurance industries, and consumer services industries. And because of that, consumer protection advocates weren't really supporting and assisting the needs of bail bonds consumers. Fortunately, in the last half decade, there's been an explosion of support for bail bonds consumers, recognizing all the ways that they are abused and that their rights are violated. The bail industry, as many of you know, and some of you have experienced, takes advantage of people who are experiencing some of the most stressful moments of their lives. Either they have been arrested and incarcerated before trial, or somebody they love has been, and they have to decide if they're going to pay to secure that person's release and how much they're going to pay. So for the last 5 years, the Bail Clinic has operated to provide legal assistance to people who had this experience And through our work, we've eliminated over $500,000 of bail bonds debt. We've secured tens of thousands of dollars of refunds for people. And we filed a class action lawsuit against Bad Boys Bail Bonds that has right now temporarily prevented the company from collecting any further money from thousands of co-signers on Bad Boys Bail Bonds contracts. In my capacity as a manager of the bail clinic, I've had the privilege of working with Center for Responsible Lending on multiple projects. When they contacted us last year and said they were interested in studying the financial consequences of bail bonds contracts on Bay Area families, I was thrilled to hear this because it's an overlooked issue that really deserves further attention. Now that they've created the report, I'm so thrilled that it'll be a vehicle to get the story out about how bail bonds are impacting especially lower income people. We partnered closely with them throughout the process, connected them with many of our current and former clients, and a lot of that is what makes up the underlying data in this report. So we've been really fortunate to collaborate with them and really grateful to CRL for putting this out into the world and making sure that more people understand how pernicious the bail bonds industry is and how much safer and healthier our society would be without it. Thank you.
Thanks, Rio. Next, we'll turn it over to Lucia Maddox to give some remarks and background about our research questions in the project.
Thank you, Charla. Next slide, please. Yes, so as Rio mentioned, we had the privilege of partnering with CRL had the privilege of partnering with LCCRSF to get to know some of the clients that they work with on a daily basis. And that we set up an intake form that we worked on with LCCRSF to finalize and wanted to talk specifically to folks who had either taken out a bail bond for themselves or for a loved one. Those were the main criteria. And also narrowing down to the Bay Area. And we'll talk a little bit about the counties that we use in a little bit. But once we were getting intake forms back from the clients that they serve, we started interviewing them on a rolling basis. And we were able to connect with 15 participants in total. And so you can, by that measure, tell that the sample is kind of super specific to folks who are able to start paying on a bail bond contract for themselves or a loved one. It does not cover the universe of folks who have been given bail as a term of their pretrial conditions or who are not able to pay at all and thus held pretrial. So this is super specific and a smaller qualitative study that we were able to do. But as you can see here, these 3 questions guided our conversations with the participants. The first being, by what means do justice-involved individuals and co-signers pay for bail in the San Francisco Bay Area? What are the financial and economic impacts of bail and bail bonds for impacted individuals and their families? And how do bail bonds affect other parts of financial life, including current or for future financial goals, both at the individual and or family and community level? And do these financial effects compound? And I would say these questions were pretty important to us, particularly at CRL. We are newer to the space of criminal legal debt, but we wanted to follow the lead of groups like LCCRSF, who have been doing this work for much longer than we have, and bring in the expertise that we have cultivated over the past 20 years, looking at predatory lenders and the nature of predatory products and services at the state and federal level. And so we argue that bail fits within that bucket, and so wanted to explore the financial impacts that impact folks who are experiencing bail bond debt. So next slide, please. So as you can see here, this map covers all the Bay Area counties within California, but we, for this study, specifically focused on 3, that being Alameda, which includes Oakland, Contra Costa, and San Francisco. But the Bay Area is much bigger, as you can see, and it's arguably one of the most expensive regions in the state. So that becomes really important when you're thinking about cost of living and the expense of bail debt that folks are having to deal with on top of their daily expenses and trying to support their families. Next slide. So within the 3 counties that we studied here, Alameda, Contra Costa, and San Francisco, here's an example of the county demographics that kind of lay out how problematic bail bond debt can be for the communities that are disproportionately impacted. So you can see, for example, with Black and Hispanic populations in all 3 counties, they have the lowest tier of income levels than their counterparts who are Asian or white. And we found in research that these populations also tend to be over-policed and thus overrepresented in the criminal legal system, not because of any culpability per se, but because of the structural discriminatory nature of over-policing in communities. That's not unique to California. It's pretty unfortunately common across the country. But this information is kind of a proxy because data on the income levels of folks who are held pretrial or are incarcerated is pretty narrow, I would say. So we weren't able to get exact numbers there, but knowing that folks in the Black and Latino community are not making as much and have higher rates of being below the poverty level gives us some proxy information that's helpful. And we did find that through the Vera Institute of Justice, their research highlighted Black people are more likely to be stopped by the police, detained pretrial, charged with more serious crimes, and sentenced more harshly than white people. So that kind of overview data is what we were able to come across without having specifics on how that plays out. But that's really important, particularly when you're thinking about the fact that the racial wealth gap more broadly, the fact that Black and brown communities hold less wealth to begin with than their white and Asian counterparts. So all that kind of factors into the overburden of bail bond debt that can happen in these communities. Next slide. So here's an example of some of the research demographics from our particular sample. And as I mentioned before, we spoke with 15 individuals and found that the majority identified as cisgender female. The majority were in the 41 to 50-year-old range. And most of our sample was identified as Black, and most identified as being unemployed. And our research also, like looking at other studies that exist out there, also shows that bail bond debt or criminal justice debt in general disproportionately falls on women and particularly women of color, Black women, because as head of household or supporting immediate or extended family networks, that's where you see the disproportionately show up. We also had some information in the report about our samples, education levels and household makeup, but didn't capture that here, but it's captured in our study. Next slide. This is also an image from our report, and it kind of lays out how the bail bond process works in general. So you wanted to give that context for folks who may not already be familiar, but bail bond is obviously one option that can be coming out of an appearance a defendant may have in front of the judge. There's a couple other conditions that can include release on one's own recognizance, a conditional release that might require other fees that might be charged or fines, outright pretrial detention if the judge determines that someone is a public safety risk or a flight risk. And as I mentioned, bail is one of the other options that is available. And if bail is granted, the defendant, they can either present cash bail in full to the court for their release, and they would get a full refund back if they show up for all subsequent trial appearances. Or if they can't afford the cash bail in full, they can secure a bail bond or surety bond and get released. And with that bail bond, 10% of the total is required up front. And that's key, and I'll get to that a little bit later. But 10% is required and is never refunded, even if charges are dropped or the person is acquitted. And as you'll be able to see, I'll share a little bit that if a bail amount can be set in the thousands of dollars, even 10% is pretty burdensome for folks and unaffordable. And if they're not able to pay anything and not even a 10% of the full bail amount, then they're detained pretrial. And when we think about it, and we've done research here too, that the median bail amount that is set is $50,000 in California. And that's 5 times the median bail amount in the rest of the country. If you think about what 10% of that is, 5,000, most people can't afford that outright. And so we found, and this happens with the what Rio and his team are seeing at the bail clinic, that bail bond contracts is essentially a financing agreement, because folks may be required to pay a smaller down payment up front, and then the rest of the premium amount, or that 10% amount, is paid in subsequent payments, whether it's a monthly or whatever schedule is set by the bail bond agent. But it is burdensome when you're talking about 10% that never gets back to the family, is extracted from that community based on, something that's a pretrial condition, not as a result of any type of conviction. And as I should have mentioned before, when talking about the different counties that we examined, in California, the bail schedule, or the amounts that are set by for a given charge, it varies by county. There is no statewide schedule for what bail amounts can be charged. And so depending on what county you're in, you could receive a different bail amount based on the charge that you received. And so that contributed to the burden as well, where if you might get charged for robbery in Alameda, that could be a different amount than if you were in Contra Costa. So we examined that throughout our report and in conversations with interviewees as well. Next slide. And here I'll pass it back to Rio to talk a little bit about the background of legislation and litigation that got us to this point in California.
As Lucia made clear, this report lays out some of the most egregious aspects of the for-profit bail industry, and especially the way it extracts wealth from low-income communities without doing anything to contribute to public safety. And yet, despite the fact that this industry has been exceptionally harmful to Californians, it has remained an incredibly resilient industry, even against many efforts to reform or eliminate it. So I want to outline a few of the recent legal and legislative efforts to change the bail industry or to eliminate it, so that there's some understanding of where we're at in terms of regulation or elimination of this pernicious industry. So as some of you may remember, back in 2018, the California legislature voted to end money bail with SB 10, and that law would have gone into effect in October of 2019. But the bail industry was able to get a referendum on the ballot, and so implementation of SB 10 was delayed. When Prop 25, the referendum, was rejected by the voters, it meant that SB 10 would never go into effect. So as of now, money bail still exists in California, despite the legislature voting to eliminate it. More recently, the state Supreme Court got involved in the effort to reform cash bail. Last year, in a decision called In Re Humphrey, the court limited how cash bail can be imposed. Among other things, the court held that courts must consider people's ability to pay before they set a bail amount. So there was some hope that this would result in far more affordable bail amounts, and bail amounts low enough that people would not have to go to bail bonds industries and sign abusive contracts. Instead, if the bail amounts were affordable, people could simply pay the full bail amount to the court. Unfortunately, recent research provided by Silicon Valley Debug suggests that In Re Humphrey is not being implemented broadly across California state courts. The research they conducted in a few courthouses in California indicated that many judges are not implementing Humphrey, the case law in Humphrey, and thus bail amounts likely remain extremely high throughout the state. Last year, there was also a legislative effort under the banner of SB 262, authored by Senator Robert Hertzberg, and that bill would have set bail for most offenses at $0, meaning that most people arrested would not have to worry about paying bail to secure their release from jail pre-trial. SB 262 did not ultimately get passed out of the legislature and does not appear to be coming back this year. So for the time being, there is no legislative effort that seems likely to eliminate or curb cash bail. All of that is to say that there is a need for major action around the bail industry. In the short term, we need more consumer protection advocates assisting bail bonds consumers and more regulators involved in enforcing laws against the industry, an industry that so often violates the laws on the books. In the longer term, people across the state, those who have been impacted by the bail system and those who haven't, need to take further action to reform or eliminate this industry. The industry, by its nature, catches people in incredibly vulnerable moments of their lives and presents to them extremely exploitative contracts. It's unlikely that Californians will be protected until this industry, the for-profit bail industry, is entirely eliminated. I encourage anybody watching today to get involved as new efforts arise in years to come to eliminate the industry through legislation, through referendums, or through litigation.
Thanks, Rio, and thanks, Lucy, as well, for the research background. Next slide. And with that, I'll turn it over to Pete Smith to share some about our thematic findings.
Hi all, I'm Pete Smith, a senior researcher at the Center for Responsible Lending, and I just want to say I really appreciated the opportunity to work on this and the opportunity that all of our interviewees gave us especially. We've got one, Lanika, here with us today, who's going to talk a little bit about one of the themes that we found in our work, but more broadly, we wouldn't have been able to do any of this work without them, and we just really appreciate the generosity and the trust that they showed us. So I'll go off camera again to talk through these thematic findings. Next slide, Eric. So essentially, we had 3 of our staff members, myself included, code the transcripts from the interviews that we did and identified findings that crossed different interviews, that we could identify things that happened to multiple panelists. And sometimes it was word for word, and sometimes it was a bit more broad than that, but we tried to kind of triple code to make sure that we were all seeing the same things. And we settled on this list of 7 thematic findings. After I go through this list of findings, I'll break them down or kind of combine them into a couple of clusters of themes. So, but to sort of introduce you to the thematic findings, and all of the analysis process, the more specific information about the methodology is available in the research report, which we can make sure everyone has access to at the end of the webinar today. The first thematic finding was bail bond contracts more than just paperwork. So not only are bail bond contracts very long and very onerous and very detailed with lots of fine print, they have a lot of ambiguity and a lot of sort of they put people in a very high stress situation, and we'll get a bit more into that. Number 2, paying premiums amidst financial shock. People involved in the bail industry or paying bail on behalf of someone who's involved are often absorbing multiple financial shocks. Paying the premium of the bail bond can be often the straw that breaks the back of the budget. This is an unexpected expense, not one that people plan for at all. And it simply adds to what is already a fairly financially precarious situation for many people. Third, and we call this being left in there would not be okay. That's a quote from one of our interviewees. When Lucia showed the diagram with multiple selections, you could see that someone who had been arrested could pay the entire bail and then it could be refundable, could pay part of the bail and it's not refundable, or they could simply remain in jail pre-trial. And so at some level, the choice to take bail is the most expensive. It has no refund possibility. But our interviewees identified for us that the prospect of being in jail for any amount of time, not to mention the externalities of being in jail, like missing work or missing school or not being able to care for children or loved ones, was so onerous and so terrible that simply being left in there would not be okay. Our fourth thematic finding was, again, identified by a quote from one of our interviewees that just said, "I'm just another number in their book." Across the board, our interviewees reported harassment from bail companies, from collection agencies assigned by bail companies, for them and for co-signers of bail debt. And many of our interviewees identified that bail companies simply were prioritizing profit over people, that the personal circumstances of the interviewees, the personal circumstances of their loved ones didn't matter one bit to the bail company. If they were at all polite or helpful on intake, they immediately stopped doing that after payments began. Fifth thematic finding, managing heavy financial loads. These are reflections on household debts and household incomes and the combination of those two. And this is where we'll have, when this one comes up among the themes, I'll pivot to one of our panelists, Lenika, who's volunteered to share a little bit about her own experience in managing heavy financial loads. And hey, Lenika, thanks for being with us again today. Number 6 is the interplay and compounding of long-term impacts. And finally, lost time, a brief look at the daily experiences of impacted people trying to make ends meet. We often found that even during the interviews that we were conducting with people involved with bail, people had to go to the post office to pick up a package, to make a payment, to look at a rental unit, to take care of a child, to do a day job. People were really managing their time very expertly, but under a great deal of pressure and a great deal of duress. So we just wanted to give kind of special recognition to how many circumstances and how much pressure people were often working under, that bail provided just one more unwelcome load on that already busy life. So now I'd like to go to the next slide and talk a little bit about themes, and we've kind of collected a few of the thematic findings into these sort of more cohesive themes. So the first is about complex and confusing contracts. The contract process is more about more than just the paperwork. It touches on experiences that folks had directly with the bail bond company. Methods for signing the contract varied wildly from in-person to phone to email, with some of those not even being accessible in various situations. The length of duress that people experience often led them to quickly signing despite a dense and lengthy contract. Again, the prospect of being in jail or their loved one being in jail, or simply the kind of fear and discomfort in the situation itself did not present an ideal situation for someone reading a detailed contract. Finally, some respondents noted language barriers. The contract wasn't in their native language. That's pretty straightforward, but definitely is a real impediment to making an informed decision. And I won't read the quote to you, but you can read, this is another quote from one of our interviewees about an experience with the bad boys bail bonds. So I'll give you a few minutes just to read this before I move on to the next one. All right, Eric, we can move on to the next one. Our next theme is the impacts of bail bond debt. And we separated some of the themes into emotional impacts, mental health impacts, lost time impacts, in addition to obviously the financial impacts that we'll get into in a couple minutes. And that's what Lenika will weigh in on a little bit. So we found it to be a forced choice when taking on bail bond debt, not really an honest choice per se. Extreme pressure and duress and obligations to secure pretrial release put a lot of emotional pressure, time pressure, and mental health pressure on our interviewees. Long-term financial, emotional, and mental health impacts of needing to pay a bail bond. The financial impacts we'll talk a little bit more about. Emotional impacts, we had interviewees telling us about lingering stress, lingering panic, kind of trigger moments that would recur months and years after bail situations. People really felt under siege in these situations. Many interviewees also were dealing with existing mental health conditions before the bail process. And so when they're already kind of working to manage that, it can make it even more difficult when there's kind of an unwelcome, sometimes unreasonable process that's demanding more time and energy from you. Finally, many interviewees notably experienced high demands on their time and money as part of their daily lives while balancing bail bond debt. And so again, we saw people really out there trying to make ends meet. And even during the interviews, they were kind of multitasking and doing what they needed to do to take care of their families, to take care of themselves, to take care of their health. And bail was obviously such a negative response that it was worth it to folks to talk with us, to share their stories in hopes that we could maybe prompt change in the future in the Bay Area. Next slide, Eric. Many panelists, many interviewees rather, described harassment and threats from bail companies. One of the most pervasive sentiments among nearly all the participants was the feeling that money and profit were more important than the people in the for-profit bail industry. Multiple respondents who served as co-signers, so they were not arrested themselves, but they were signing as a kind of a guarantor of the loan, the bail loan, noted that not understanding what they got themselves into and wondering ultimately who was on the hook for the debt. And if they don't know who is on the hook for the debt, then that's a kind of an advantage for the bail company and for the collection agency, who, according to our panelists, would harass basically anyone and everyone that they could with any connection to the debt. So if your name was anywhere near it, you were probably going to hear from the bail company or a collections agency. Finally, in our themes, and Eric, you can go to the next one. Finally, in our themes, bail bond debt simply adds to already unmanageable financial debt burdens. Interviewees did not have a clear understanding of the differences in the types of payments to pay toward a premium. For instance, 10% of the total bail amount, non-refundable, being the kind of, that's the typical premium, but the payment structures were often very different. Often a company would take whatever they could get from on the front end and then structure the payment so that people were paying even more after. Again, people were not making ideal decisions under ideal circumstances, and so they might agree to this, not knowing that later on they would have to pay much higher parts of their premium or of the bail amount. And it's evident from this research that the compounding burden that bail debt places on most participants, but especially those who are Black and Latino and or low income and low wealth. Again, these are communities that are over-policed, that encounter the justice system and encounter the bail system more than others, more than white folks. And we found that the burden that bail put on folks was greater for those communities too. And here's just a short quote that you can read, and then I will hand it over to Lanika, who's going to talk to us a little bit about her experience in managing her financial load during a instance with the bail company. So again, Lanika, thank you for being here.
You're welcome. Thank you for having me. Hi, everyone. My name is Lanika Howard, and I didn't get arrested. My son was arrested. And so it seemed like for 3 years, it was once every year he would be arrested, and that would be at least $5,000 that I would have to, not have to, but that I helped co-sign to get him out on. And the payment, so we would usually put down maybe $2,000, and then the bail amounts on a monthly basis would be $250. But for me, I was looking at it as my son's gonna pay this debt. I'm not paying this monthly debt for him because that's another bill on me that I have. I'm the head of household, so I'm taking care of my children. I have 2 adult sons. I have a granddaughter, and then I have my son's girlfriend, the mother of his child, living with me as well. So I'm one income taking care of 5 people. My younger son is in college, so I'm helping him with college. I have so many things that I'm trying to do in addition to taking care of myself. So it is a very heavy load for me as a person, as a mom. And then to have the debt of bail bonds and the people calling and harassing, and it being, I can identify with everything that is on the list, but I just chose to talk about the heavy loads and managing managing your income with having to pay debt to a bail bondsman and your debt to income ratio, adding that bail bonds debt onto what we already have as people going on in the world, rent, car payments, buying food every month, paying for medical things, whatever it is we have to do. In addition to that, having to pay an extra $200 or $300 to a bail bondsman, it was very overwhelming. And I had to come to the point where I told my son that I could no longer help him bail out, and that crushed me as a mother, to have to tell him if he ever gets in trouble again, that I just can't do it, because it was affecting me and my credit as well. When you don't pay those premiums that you sign, the other thing is you don't really understand, and I know I'm getting off topic, but you don't really understand the contracts. And when you're signing these contracts, you don't really know what you're signing. No one reads the whole contract. It's too much paperwork. And you're having to sign this contract pretty quickly. The bail bonds company wants to get it done and over with. So you're going in, and sometimes you don't go in. You may get something in an email that you're signing. So to have to go through all of that as a process is very overwhelming. And then for me to have to tell my son that I can no longer help him bail out of jail if he ever gets in trouble again, that bothered me. And then on top of that, the cases that my son was arrested on didn't even go to trial. Maybe a month later, the case was dropped. So we've spent $5,000 that we cannot recover on him just being arrested. And it's just, it doesn't make sense to me why we are still going through this process. Even as voters, we voted that we don't want the bail process, and how legislation and the powers that be cannot get it together enough to do what the voters are asking them to do. And that's all I'll say about that.
Thanks again, Lanika, for being with us and for sharing your perspective. We, again, just really appreciate it, and we couldn't do it without you.
Thank you for having me.
So now I'll talk a little bit about, in the next slide, some of the recommendations that we assembled for looking at the findings and talking with our partners and talking with our interviewees. First and foremost, we identified that the interviewee stories, the central part of this work, paired with the existing research that we could draw from other folks, made it clear to us that the use of cash bail in the pretrial system results in wealth extraction from low-income communities and Black and Latino communities especially. Leads us to conclude that cash bail and the entities that take advantage of its use must be eliminated. Finally, local and state judges should prioritize determinations of fair, non-punitive pretrial release that strengthen communities and maintain public safety. So that concludes our the presentation part of our webinar here. We would like to open it up to a question and answer period after this, and we'll have about 20 minutes for that. Before I pivot to that, and I'll come back on camera here for that too. Is there anything that anyone else, any of the other panelists would like to share before we get started with the question and answer?
I'll just say just one thing to add. Thank you, Pete, and thanks everyone, Rio, Lanika, Charla. The one thing I'll add that some folks may already know on this call is that, bail is pretty unique in the United States, period. It's only one of 2 countries that use this system at all, the other being the Philippines. And so when you're thinking about alternatives or what the vision could be post cash bail, there are other countries that have alternatives. And there's even other states in this country that are exploring what reforms and bail elimination could look like. So it's not a foregone conclusion that this can happen in the future. So just wanted to add that piece.
Thanks, Pete. Thanks, Lucia. And thanks to all of our panelists for your words and your contributions to this project. We'll segue into our question and answer period. So folks, if you have questions either about the report or anything that was shared during this webinar, feel free to enter those into your question and our question and answer box at the bottom of your screen. We do have a few questions that have come in so far, and I would invite any of the panelists to share their perspectives about this. But the first question is there any risk that eliminating cash bail could lead to judges jailing some people pre-trial who would have previously been eligible for cash bail?
Hi, yeah, thank you for that question. And yes, there is some risk of that. In eliminating cash bail, you have to do so thoughtfully. Just like any other policy, it can have unexpected consequences. For instance, when SB 10 was passed by the legislature, there were a number of features of that bill that many advocates for reforming or ending cash bail disagreed with. There were a number of ways that people could end up incarcerated pre-trial simply as a result of algorithms that were based on racist data that tended to disproportionately indicate that people of color or lower income people should be incarcerated pre-trial. That was part of the reason that people opposed SB 10 and that some people voted to ensure that it never went into effect. However, there are states that have already eliminated cash bail, like Illinois, and it's possible to do so without increasing the number of people who are detained pre-trial. What's most important is that if somebody is going to be detained pre-trial, it be for clear public safety or concern about their likelihood of appearing at future court dates, and that courts have to justify those determinations and do so under a high standard. Rather than having a legal system that determines who should be incarcerated pre-trial based on who has the most money, those reforms would shift us to a system where the determination about who is in jail pre-trial is based on who is most likely to constitute a threat to public safety or who is least likely to appear in court at a future appearance. So there are systems that have already been implemented that strike that balance. There is also policies being formulated right now in California to be proposed next year or the year after that would strike this balance much better than SB 10 did in California. And as I said, what we need is a system that doesn't make this pretrial incarceration decision based on somebody's wealth, but instead based on objective determinations that are determined under a high standard by courts and that can be challenged.
Thanks, Rio. Another question came in. Is there still political momentum for reforms, or are media-driven stories about increasing crime closing the window of opportunity? And I'm not sure if this is specific to California or the nation at large.
I could speak just briefly to this and say that this became, especially, there was a lot of talk about this in the few weeks after District Attorney Chesapeake's recall election in San Francisco, and a lot of the kind of media narrative around his recall was about people being tired of crime and an increase in crime in San Francisco. Now, My understanding is that the facts around that increase in crime are mixed at best as far as that narrative goes, but a lot of money was put into that election for the recall. However, it was also pointed out to me that while many voters did choose for the recall of District Attorney Boudin, that many of the policies that he represented and many of the policies that he voted for and enacted in the district attorney's office were met with broad public approval. So I think there was a situation where I don't think everyone was responding necessarily to criminal justice or criminal legal debt reform efforts, but simply that people had been caught up in a fairly well-funded media narrative.
Thanks, Pete. Any other thoughts or responses to that question?
I would just add that more broadly, I think there's the ebbs and flows of when the media kind of latches on to certain narratives around crime waves. And it's kind of always like a backlash to, okay, these reforms are attempted, and then there's a wave to push back on it. And even in Illinois that Rio brought up, before I think the bill is going to be, or the law is going to be enacted in the new year. And the opposition is kind of ramping up, like trying to block everything that they can, including weaponizing the media to try and block that from implementation. And so I think that there is always a window of opportunity to work on these types of reforms. And it's really that keeping to that long-term vision and having to navigate, unfortunately, the political and public narrative waters, but knowing that the underlying problem is consistent and arguably getting worse. Like these debt burdens are just, they're not going away clearly. And in the absence of regulation on the bail industry, it's clearly allowed to thrive and continue taking advantage of folks.
Thank you both. Another question related to the bail bond company and industry. Does a single bail bond company tend to operate in a single county, a single state, or is the industry highly consolidated into a few major companies that operate all over the place? And does this industry structure matter to reform efforts?
It's a great question. Thanks for that. And we've seen sort of two tiers of bail bonds companies primarily. There are a number of large companies that operate across the state or even sometimes in multiple states. There's four in particular that we've dealt with: Bad Boys Bail Bonds, All Pro Bail Bonds, Aladdin Bail Bonds, and Bail Hotline Bail Bonds. So they operate in multiple counties and sometimes multiple states. There are then a number of other bail bonds companies that are far smaller and tend to just have one or two locations, often in just one jurisdiction. In terms of what implications this has for reform efforts, I'll say two things. First, it hasn't complicated reform efforts much. Most of the reform efforts in recent years would apply similarly to all bail bonds companies, and were not made real complicated by the fact that there are different sizes of bail bonds companies and different levels of industry concentration in different places. So for instance, creating a $0 bail for most offenses, that would affect all bail bonds companies indirectly and isn't really impacted by the fact that some are larger than others. Similarly, eliminating cash bail entirely will affect all companies equally, regardless of their differing sizes. The one area that it has mattered is that there has been litigation ongoing for years, antitrust litigation filed against the bail industry, arguing that there's been unfair cooperation amongst different companies in the bail bond space, where they've basically been been sort of a price fixing and agreeing on a amount that they would charge consumers and sort of undermining the competitive instincts in an industry. And that litigation, I believe, has sort of relied on the fact that the industry is fairly concentrated, that there's four really large companies, that those companies are all organized in an industry trade group. that facilitates a lot of communication and strategizing amongst those companies. And so to the extent that there is some concentration in the industry, it has been a focus of reformers, legal reformers, who have tried to take issue in court with the monopoly tendencies of these companies and their conspiring in ways that appear unlawful.
Thank you, Rio. I have one other question from the audience, unless there are others that will come in. This one is, when payments are missed, can bail bonds companies revoke the bail and force the defendant to return to pretrial detention? Or is the response usually to just try and collect the unpaid debt?
So bail bonds companies cannot legally use non-payment as a grounds to rearrest the defendant and return them to jail. They do have authority to return the defendant to jail in some circumstances, and they'll sometimes use those other reasons as a pretext for returning someone to jail, when in fact what they're trying to do is punish people for non-payment. They often threaten to rearrest people if they do not pay, but again, they cannot legally rearrest somebody solely because of non-payment. They're what they're able to do in response to non-payment is pursue debt collection practices and file litigation either in small claims court or civil court in order to collect that money through typical debt collection procedures.
Yeah, thank you for that, Rio. And I would just add, like, as one of the themes that Pete talked us through earlier, they'll often harass people even sometimes before the payment is due. So if they agreed that there would be an initial down payment and subsequent payments that might be on a monthly basis, we found some interviewees were telling us that they were getting calls or texts before the agreed upon due date. So beyond whatever legal action folks can take, they definitely use scare tactics ahead of actual legal action, which is problematic in and of itself.
Thanks, Rio and Lucia. Rio, you started speaking a little bit to this around debt collection agencies, but we did get a question about, do bail bonds companies typically rely on collection agencies to collect debt on their behalf? Is this important when assessing if financial regulators can take action?
Yeah, thanks for that question, Brianna. It varies. Some bail bonds companies handle all of their debt collection in-house. That's the case for Bad Boys Bail Bonds, for example. Other companies rely heavily on third-party debt collectors. Take Aladdin Bail Bonds, for example. And this does have some implications for our ability as lawyers to address violations. There is a federal Debt Collection Practices Act that we sometimes utilize, but we can only use that against third-party debt collectors. We can't typically use that against the original creditors or the bail bonds companies. However, there's also a parallel law in California called the Rosenthal Act, and that law can be used against both the original creditors, the bail bonds companies, and the third-party debt collectors. In terms of whether there's a role for insurance regulators to get involved, Center for Responsible Lending and the Lawyers Committee both believe that there's certainly a role for regulators to play a more proactive, to take a more proactive role in addressing problems in the industry. And in terms of the regulations, regulators can go after either the bail bonds companies or the third-party debt collectors for violations. Most of the laws that the regulators are enforcing apply equally to both the bail bonds companies and the third-party debt collectors. As of January 1st of this year, under the Debt Collection Licensing Act, both bail companies and their debt collectors are supposed to be licensed under state law as debt collectors. And that is supposed to eventually help the agencies better track who's doing debt collection and who is complying with or violating the debt collection laws.
And Rio, I don't know if this kind of complements what you were saying, but talking about the other consumer credit protection laws that may apply here based on the work that you've done, would you be able to speak to that a little bit, or kind of piggyback on what you talked about earlier.
Yeah, no, thanks for the assist, Lucia. I forgot to plug the fact that, our class action lawsuit against Bad Boys is based on a consumer protection law that is available for lots of different consumers in California, but had never been applied against the bail bonds industry. And this is a consumer protection law that says that if a consumer is signing a consumer credit contract, they must be provided a 2-paragraph notice outlining their responsibilities as a cosigner in English and in Spanish. That law exists, as do a number of other laws that are specifically meant to benefit consumers and sometimes consumers of credit contracts. So another one, for example, is the Consumer Translation Act, which says that if a consumer negotiates a contract in a language other than English, they typically have to be provided with a translated version of the underlying contract in that same language. And where that doesn't happen, they have a number of remedies available to them. Those are just 2 examples. There are other consumer protection laws. I mentioned the Debt Collection Practices Act. Those are big ones. The Consumer Legal Remedies Act, the Unfair Competition Law. These are all consumer protection laws that are available to bail bonds consumers and may be used to vindicate their rights when the bail bonds industry violates them.
Thanks, Rio, and thanks for that follow-up question, Lucia. This question was one that I had for Lenika. You shared a little bit about the ways the industry and the ways that having a bail bond debt affected some of your finances in the short term. Can you share a little bit, if you feel comfortable, about ways that it has or has not affected your finances or your financial outlook long term?
Yes, I can share a little bit. So with the debt, when you don't pay your premiums that you're supposed to pay, or the bill you're supposed to pay every month to the bail bonds company, they do put that on your credit, and they put the full amount that you owe them, and it shows up as a debt, and it can affect your ability to acquire credit, to acquire housing. As a matter of fact, during the time that I was doing this interview, I was searching for a home for my family, and that debt was on my credit report, and it was causing a problem for me to be able to get new housing. And I had to go through the process. I called Lawyers Committee for Civil Rights. Well, actually, they contacted me, and I went through the process to work with them, to work with an attorney to help me get debt relief. And I actually did get some debt relief. So it helped a great deal, but it took a long time to get that debt off my credit report. And I didn't even know if I actually could get it off my credit report. So yes, it affects us in a major way in every aspect of our lives.
Thank you for sharing that. And again, thank you for joining us here on this webinar. And to there were 15 individuals that we interviewed. Not all of them could be, of course, here with us today, but thank you to them as well. I know we have about a minute left, so I'll open the floor to see if Pete, Lucia, Rio, or Lenika have any parting thoughts or last reflections that they want to share with the audience.
Thank you so much, Charla, and to all the panelists here and all the participants we had. I just wanted to leave the note that this obviously wasn't an exhaustive report, but our goal was to help it complement the advocacy efforts that our partners throughout the state and across the country could leverage in the future fight to eliminate cash bail. So hoping it could be one extra tool in the toolbox to help move that forward. So.
And once again, just thanks to all the panelists, thanks to all the interviewees especially, and thanks for tuning in and listening to our research presentation today.
Thanks to everyone. If you are curious or want to look at this webinar later on, there will be or is a recording of this webinar, as well as we encourage everyone to check out the report, and you're welcome to email Lucia Lucia or Pete. Their email addresses are on the slide if you have any questions either about the report or about the webinar. We really appreciate everyone's attention and thanks so much for joining us.
Thank you. Thanks, everyone. Thanks, Trevor.